Hi, and welcome back to Hill and Pond's Veterans Disability Blog. I'm Natalia Jofre, the company's COO.
And I'm attorney Allison Reddick.
So, Allie, today I want to talk about something that is very bothersome to me, very concerning to me, because we see this so often where veterans aren't awarded what they should be. Either they're denied completely, but almost even worse, I would say, they're given a very low rating percentage. And the reason that concerns me is because then they think that's all they're entitled to. So I want to first bring it back to the basics, and then maybe we can get into some more detail. So I think that the first thing is if you could explain to people what a rating is.
Okay, so basically what a rating decision is, it's a document that you'll receive that basically says that the VA has reviewed your claim and made a decision on it. It will state whether you received service connection or not, and if you did, it will include the evaluation they give you and the effective date. The rating decision should cover what evidence was considered. It should include the regulations that were used to make the decision.
Okay.
And in the new Appeals Modernization Act system, it should include favorable findings. So what positive things and positive evidence that were used to make the decision.
Who's making the decision?
So basically, it's a rater. It's someone at the VA who goes through your evidence, goes through your file, and determines whether you have the proper elements for service connection, or if it's increased rating, the proper criteria for an increased rating. If you appeal a decision, then it's going to be someone higher up with a little more qualifications, a little more experience, who will be making the decision that time.
So based on what you just said alone, this tells me that a less experienced person is making that initial determination. You perhaps are not getting the best of the best making a decision on your claim, right?
Right. And they're going through thousands of files. So they're trying to get through them as quickly as possible. So when a veteran gets a 0% or a 10%, a lot of times they're happy they're service connected, but the evidence in their file shows that they should be getting a 50%, a 70%. So it's really important to not settle with that first rating you get.
And I think that that's why I find it so bothersome. It really makes me sad. And I meet, I do these events and I meet veterans all the time, and they're so grateful because they're getting 10% and they'll get 10% for 20 years. And then you have a conversation with them and you're like, oh my goodness, the severity. They're not able to work. They're not able to hear. They're not able to function in society. They have all of these limitations, or it's such a struggle for them, and they're getting 10% and they're just grateful that, at least I'm getting 10%. So I think that one of the things I want to convey today is you shouldn't just assume that because that's what the VA awarded you, especially the first time around, that that's what you should stick with, or that assume that it's accurate.
Absolutely. And included in your decision, it should state what criteria is necessary to get the next highest rating. So it's really important to read your decisions thoroughly so you can see, hey, wait, I experience all of these symptoms or some of these symptoms in the next higher criteria. I've been experiencing them before I filed my claim. I should probably appeal this decision. Or if at some points, years down the road and your symptoms increase, definitely file for an increased rating.
Can you give everyone a little bit of an idea of what a difference in the compensation rating will make? So for example, monetarily speaking, what's the difference between 10 and 50%? Or 30, whatever example you want to give.
So a 10% rating is around $140. Then it slowly increases. And by the time you get to 50-60%, you're going to be above $1,000.
Wow.
But then getting 100% rating, that's around $3,100 a month.
That's a huge difference.
Yes.
So from 10, you said, to about 50. I mean, you're talking about getting 10 times more than what you would be receiving at 10%. So that's a lot of money over a significant period of time. And you said, so if initially you get 10%, and perhaps at the time that's an appropriate amount, if you later get worse, you can later appeal or file for more?
Absolutely.
Okay.
So when you get your rating decision, you have 1 year to appeal that decision. So let's say you get a decision in September. Come April the following year, your symptoms are worse. You're still within that appeal period, so you can file an appeal to that decision. If it's years later, you can file a 526EZ for an increased rating for that condition.
Okay. Are there any risks involved? Because I hear this concern often where people say, I don't want the VA to look at my claim. They're afraid that they're going to lose what they have. Are there any risks involved in asking for an increase?
Yes. So when you're putting someone's hands in your file, there's eyes looking at everything. So there's always a risk that they could potentially reduce your percentage. I don't think you should worry about that, though, if you have documentation that you have these symptoms on a daily or frequent basis. I think what's important is that you have documented evidence from your physician. You fill out disability benefit questionnaires, which you can get online from the VA, have your doctor fill those out, even have lay statements from yourself, from your spouse. I mean, who knows more about what you experience than your spouse? A lot of veterans downplay their symptoms, and spouses or other family members are very good at saying, oh no, he says his pain's a 2. I see him bent over, in bed, writhing in pain. That's not how it is. Even if they were to reduce your percentage, they have to give you notice for it. So what they'll do is they'll send you a proposed rating. And in that proposed rating, they'll say, you have a 30% rating. We plan to reduce it to 10% because of these reasons. You can ask to be heard and ask for a hearing and submit evidence to say, no, that's not true. That's not what I'm experiencing. And a lot of the times that comes from the C&P exams.
Okay. Is it a frequent problem where people are getting reduced, or is it more likely that you'll get increased than you'll be reduced benefits?
If you're providing evidence that you're having these symptoms that fit the higher criteria, you're more likely to get increased. The only times I really see reductions is if it's a bad C&P exam, unfortunately, but those are things that can be remedied at some point by asking to be heard on that issue. I definitely think as long as you have the evidence, you're much more likely to get increased than decreased. I don't want people to be afraid to file for increased ratings because of reductions.
Right.
They're not, majority of them are not trying to reduce you. It's just making sure that you have the right evidence.
It's almost as if though it's a potential issue that could happen. So you need to be aware of it, but it's not the most commonplace thing to occur.
No.
You're probably more likely to be increased or left the same than to be decreased, would you say?
Absolutely. And sometimes when you have routine compensation and pension exams, during that exam, they'll even say, oh, your symptoms are better, but you've had past exams where they were worse, so we're going to keep you at the same rating. So they may even say something like that. So I really wouldn't worry about reductions unless your symptoms have actually decreased.
Right. There's one thing that you mentioned that I think we should expand on just a little bit in terms of the documentation. So when you're talking about documentation, I'm assuming this is you are frequently or at least going to the doctor when you're supposed to be going.
Yeah.
So, having those scheduled visits, if exams are ordered, you're keeping those exams. If you're taking, if they're prescribing medication, you're being compliant. The people that normally have issues, probably, I would think, are people that have gaps in their treatment. So in other words, I'm asking for an increase, but I haven't been to the doctor in 2 years. Right?
Yeah, I would agree with that to an extent. I would say you don't need to go to the doctor every week or every month.
Right.
It's just having a continuity of care. If you see your doctor twice a year and you're taking the medication that you're supposed to be taking, then that's fine. As long as you just don't stop going to the doctor for 5 years. However, in this society with medical insurance, sometimes that happens. So don't be discouraged if you are in that situation and you haven't been able to go to the doctor That's where lay statements from yourself, from your family, from your employers are very important, because that evidence has as much weight as the medical evidence.
Really?
Well, I mean, of course, the medical evidence is going to be more, is going to be better, but it does carry significant weight. They have to review it. They can't disregard it.
They can't just be like, well, this is the wife giving a statement. I'm not going to pay attention to this.
Now, a lay statement, they can't diagnose you, but they can state their observations. They can say what they experience on a daily basis and how it affects your daily living. Absolutely. That is great evidence.
Okay. How can you ask for an increased rating? So 2 phrases or terms that I hear swirling around a lot lately are the legacy system, and AMA. So can you explain a little bit about what those 2 are and what the difference is, I guess?
So legacy, we're to the point where you can't file anything in legacy. Everything is AMA. The only way you would be in legacy is if you have a pending appeal that is still being worked.
So these are 2 different claims paths.
Yes. So prior to February, I believe 19th of 2019, it was legacy.
Okay.
On that date, AMA started.
Okay.
So February 20th, you go more forward, you had to file a 526 EZ to file a new claim or file an increased rating.
Okay.
Prior to that, you could write on a 4138 statement in support of claim, I want an increased rating. But now they're very strict about putting it on the proper documentation.
Okay. And what needs to be included in that? And are there big differences between what was required then and what's required now?
No, I mean, the 526 EZ still existed, and that was something you should have used. But basically, it's just information about yourself and where you're getting treatment and listing whether you're asking for an increased rating or service connection. You're not really giving too much information. However, I would suggest submitting additional evidence with that form. It's just a form to put in to say, hey, I want to file a claim. What's interesting is that you can file an intent to file prior, and for up to a year, let's say, and you're thinking about filing a claim. So you put in the intent to file, and as long as you put in that official document within a year, you can go back to the date of that intent to file.
Okay, great. So we often hear about things that the VA gets wrong. Is it possible that they can get an effective date wrong?
Yes. Effective date is something that is commonly wrong, especially when you're filing for an increased rating. If you file a new claim for an increased rating and then you have a compensation and pension exam and then your rating comes out, a lot of times they will give you the date of your compensation and pension exam, because they'll say, that's the date that these symptoms were noted. That's the date we're giving you. That's not always right, especially if you have evidence prior from your doctor or in your medical record or lay statements showing that you had those symptoms prior. You should get it back to the date that you originally filed that new increased rating. Now, let's say you have a claim that you filed a year ago. You just got a decision, you're still within the appeal period, you want to get an increased rating. If you have had symptoms, documented symptoms, all the way back to that original claim, it's as long as you continuously appealed it, you potentially can get an effective date all the way back to that original claim.
Wow, that's significant. Okay. When should a veteran consider applying for individual unemployability?
I think it really depends on what conditions you have and how disabling they are. Certain conditions are extremely disabling to the point where you can't work. And so it may take time for you to get the correct ratings, but I would go ahead and apply for it when you stop working. I mean, that puts it in and puts the VA on notice that these conditions are affecting your ability to work. A lot of conditions that I see that severely affect your ability to work, back conditions, migraines, if you're in remission from cancer, the residuals you have, things like that. I don't think that it necessarily matters when you put it in, as long as you put it in, because if you're not scheduled qualified, they're going to deny you.
Right.
But it puts in at that point, you were having these issues and you were unable to work, and it shows the VA, okay, this is an issue that we should be looking at in the future.
Okay, that's great. Thank you, Allie. That was super helpful. All right, so we're going to keep talking about VA-related topics, of course. In the meantime, if you have questions, please feel free to visit our website or call our office.
Thank you.